Hi, my name is Mike Kalish. I'm an attorney. I'm located in Southern California, and my law practice focuses exclusively on representing individuals on claims for disability benefits from the Social Security Administration. In this video, I'm going to talk today about what happens when Social Security says no. I believe that the best way for me to get this information across is to provide an example, a story, if you will. So, we have John. John's about 48, 49 years old. He's married and got a couple kids. Up until a couple years ago, he worked full-time in the finance industry, did pretty well at it, made good money, was able to support the family. They bought a house. And then, unfortunately, a couple years back, he had a car accident. In the car accident, nobody really got hurt, or so he thought. He was the driver. The back was a little bit sore, neck a little bit sore, but he was a young guy. He's been in worse scrapes, so he thought, give it a little time, it'll resolve itself. Unfortunately, as the months went by, the problem did not resolve. In fact, the pain got worse and worse and worse. It got so bad that it reached a point where even sitting for more than 10 or 15 minutes was simply too painful for him to do. He'd have to get up, try to stand, shake it out. 10 or 15 minutes of standing. Again, the pain was such that he'd have to sit down. Finally, he started going back to see his doctors. They did some tests, and lo and behold, he's got a couple of herniated discs in his back. He's got some problems with his neck. They may have to do surgery. But he's reached a point where he's unable to physically do the kind of work he's done in the past. In fact, he doesn't even feel that he could do any kind of work, even work that would be less intellectually demanding. Maybe going back and working, what he did in high school, taking tickets at a movie theater, being a greeter at Walmart. The problem is that he just is unable to stand for very long. He's unable to sit for very long due to the pain. So one of his doctors says, if you're unable to work, maybe it's time to think about filing for Social Security disability. And it's the first time that John's ever heard about this program. Of course, everybody he knows about the retirement, Social Security retirement. What's this disability program about? Well, he finds out that Social Security actually has a couple of programs to assist people who are unable to work because of a medical condition, but who are too young to collect their Social Security retirement. Excited, he fills out the applications. It's a lot of paperwork. He has to provide information concerning his doctors, concerning the kind of work he did in the past. He has to get statements from some people who know him, talking about what his limitations are now. He submits all of that to Social Security. They actually may send him out to see one of their doctors. He goes in and he has a very odd examination. The examination lasts maybe 15, 20 minutes. But he figures they know what they're doing. He knows his doctors are telling him he can't work. This should be a slam dunk. And then about 6 or 9 months after he's filed his application for disability benefits, in the mail, he receives a letter from Social Security. And it looks something like this. And at the top here, on the top left-hand corner, it says Notice of Decision. Excuse me. Notice of Disapproved Claims. Can be either way. Notice of Decision, Notice of Disapproved Claims. You see that up there. It's dated, and it says, we're writing to you about claims for Social Security disability benefits based on a review of your health problems. You do not qualify for benefits. This is because you are not disabled. The following reports were used to decide your claim. Lumbar MRI report received. You said you were unable to work because of low back pain, neck pain, and depression. The medical evidence shows that your condition results in some limitations in your ability to perform work-related activities. However, we have determined that your condition is not severe enough to keep you from working. So what they're saying is, yeah, we get it that you have a problem, John, but we looked at all the evidence that you gave us, and we don't think that you're precluded from all work. You can still do some kind of work, so we're going to deny your claim for benefits. So he's kind of in shock. So let's stop at this point. The doctors are supporting him. He had medical records. He's not making this up. He certainly would much rather be working and earning good money rather than collecting his disability check, which is going to be a lot less than what he was making when he was working. What's going on? How did this happen? Well, what John needs to understand is that about 65% of all individuals who apply for disability benefits are denied initially. When they first apply, that initial application, 65% are denied. Okay, that statistic is true in California, where I practice. It is true across the country. So what do you do? What does John do? Well, buried deep in that letter that he received, about 3 or 4 pages in, it talks about if you disagree with this decision, you have the right to appeal it. Well, how do you do that? Well, you have to file something called a request for reconsideration. You're going to ask Social Security to reconsider the denial of the claim. It's a simple form. You could find it online. Just Google request for reconsideration. It'll pop up. This is a sample of what it'll look like. You'll see right up there, it says request for reconsideration. You're going to fill out the information, name, Social Security number. Issues being appealed are going to be disability insurance, maybe SSI. There's a statement, I do not agree with the Social Security Administration's determination and request reconsiderations. My reasons are, and this you can keep very simple, I'm entitled to disability benefits under the Social Security Act. You don't need to give a big, long dissertation as to why you believe you should get your benefits. You just have to say, I'm disabled, I'm entitled to benefits under the law. You fill this information out. At the bottom, there's contact information. You're going to put where you can be reached at. If you're represented by an attorney, you put that information in there. If you're represented by the attorney should be doing this for you, but if you're on your own, this is how you do it. Signature, interestingly enough, is optional. You don't need to sign this thing. Probably a good idea if you do. Now, you have 60 days off the date of that notice of disapproved claims. And you see on this one, the date is February 6th, 2018. So you have 60 days from that date to get this request for reconsideration back to Social Security. If you do that within the 60 days, you can mail it to them. You can walk it into the Social Security office and hand it to them. When I do that, I always ask for a file marked copy stamped back so that I have proof positive that I filed it within the 60 days. If I mail it in to Social Security, I will do it by certified mail. So again, I have proof positive that they received it within the 60 days. Or you can do this online at the Social Security website. And when you complete the request for reconsideration online, they'll provide you a confirmation number that they're in receipt of that. Keep that. That's your proof that you did it. All right, so you've got your request for reconsideration in. Social Security basically is going to ask you to do all the same things you did the first time around. You're going to have to update them on information about your doctors, any new treatments, where they can find the records at. John does all that, and additionally, John provides a statement from his treating doctor explaining why his doctor thinks that John is unable to work. 6 to 9 months pass by. Social Security may send John again out to see a doctor, where he does it again, the 15-minute examination, touch your nose, touch your shoulders. Thank you very much. And after about 9 more months of waiting around with no money coming in, he gets a second letter from Social Security. This letter is called a Notice of Reconsideration. See that up there, Notice of Reconsideration. And in this one, this letter says, you asked us to take another look at your claim. Someone who did not make the first decision reviewed your case. All right, a different group of people looked at it. And we still find that you're not disabled, even though you gave us some updated records. And by the way, you gave us the statement from your doctor. But we still think, based on our rules, you don't meet the definition of disability. So again, the second been denied twice. And again, what I would tell John is it is highly unlikely that on this second evaluation, this reconsideration, that you're going to be approved for disability benefits. Statistically, 80% of the folks who request Social Security to take a second look at their claim for disability benefits, 80% are denied. So 65% are denied initially, 80% are denied at reconsideration. Now we're a year and a half into it. What does he do now? Money is running out. In that letter for that notice of reconsideration, just as in the first letter, it talks about 3 or 4 pages in, it says, well, if you disagree with this, you have a right to have a hearing before a judge. Same deal. You've got to request your hearing before the judge within 60 days on the date of this letter. Otherwise, we're going to close out the claim. So John, being very proactive, files his request for a hearing. Same thing. He's going to use a type of form. It's called basically the same thing as before. It's called a request for a hearing before an administrative law judge. Again, you can find that online. Just Google it, request for a hearing before administrative law judge, Social Security. It'll pop up. You fill it out. It's basically the same thing. It's a 1-page. All you have to do is say, I disagree with the decision. I'm entitled to my benefits under the Act. Same thing. You file that with Social Security. You can do that either online at their website. You can do it in person in a Social Security office. Again, if you take it in person, make sure you bring a copy. Ask them to file stamp it for you so that you have a copy for your records. And you can mail it in. Again, when I do it, I mail it in by certified mail. So again, I have proof that we submitted the request for the hearing within the 60-day window. The time to get a hearing before an administrative law judge is going to take anywhere, quite frankly, from a year to a year and a half. It is a long process, but here's the thing. If you push through to the hearing level, this is where most people get on benefits. This is where things turn around. Initial level, 65% are denied. Reconsideration level, 80% are denied. But at the hearing level, 60 to 70% of the folks who go to hearing and who are represented by counsel, who are represented by experienced counsel, people who know what they're doing, lawyers who have experience in this, 60 to 70% of those folks will be approved their disability benefits. What'll happen at that point, if you're approved, is Social Security, the judge will order Social Security to reimburse John for all the time that he's been waiting for his claim. The judge will say, hey, you guys should have been paying him from the get-go, reimburse him, and start giving him a check going forward. All right? So the moral of the story is you have to be persistent. You have to push through and fight for your rights, because Social Security, certainly before you go see that judge, that independent judge, Social Security Administration, they are more likely than not to deny the vast majority of, well, they're not more likely, now they do. They're going to deny the vast majority of claims for disability benefits. It is a difficult process. It is a time-consuming process. So, of course, first question that pops into everybody's head is, well, you're telling me this whole thing, more likely than not, is going to take anywhere from 2 to 2.5 years before I get a resolution and I see some money. And unfortunately, that is very true. Social Security is very slow. It is going to take several years, more likely than not, before you see any money from them. So, what do? Well, if you're fortunate enough to be a resident of the state of California, the state has a program where the state will provide you about a year's worth of disability benefits. It's called short-term disability insurance. It's provided through the employers, through the state of California, through worker contributions. And it pays out about 55% of what an individual was grossing when they were working, and you can receive payments for anywhere from 9 months to a year. Obviously, 9 months to a year for most people is not going to be enough time to cover all the way through while they're waiting for their Social Security claim to work its way through the system, but it will help. It is somewhat of a stopgap for that period of time, and something is certainly better than nothing. The moral of the story is, as soon as you reach that point where you're pretty positive you're unable to do not only just your old job but any kind of work, you need to get that application filed with Social Security, because more likely than not it's going to be denied. More likely than not you're going to have to do what most people do and push through to see a judge before the matter's going to get resolved, hopefully in your favor. So that's the process. Moral of the story is, don't give up. You have to push through. More likely than not, if you do stick it out and get through to that hearing before the judge, if you've got the records, you've got some decent representation, you have a better than 50-50 chance of being awarded your disability benefits. So if you have any questions, you can take a look at my website. I have some information on the website on how to actually qualify for disability benefits, what Social Security looks for, how they evaluate a claim for disability benefits. And you're certainly welcome to give me a call. My phone number here is 714-548-3292. Again, it's 714-548-3292. The website is www.thesocialsecuritylawyer.org. Again, my name is Mike Kalish. Thank you for watching. I hope you found this helpful.